Hello and welcome. My name is Mohammed Ranavaya, and I'm currently the Associate Dean of CME, as well as a Professor of Medicine at Marshall University School of Medicine. With me is Mr. Paul English Smith, a very senior attorney, and in a moment I will introduce you to him. Thank you for participating in CME On Demand Enduring CME activity, which today's title is Consent and Informed Consent. This program has been reviewed and approved for American Medical Association Physician Recognition Award Category 1 credit by Marshall University School of Medicine, which is an accredited provided by the Accredited Council on Continuous Medical Education. Mr. Paul Smith is a Senior Vice President and Chief Administrative Officer for Marshall Health Network, a healthcare system in Huntington, West Virginia, composed of Cabell Huntington Hospital, Rivers Hospital, St. Mary's Medical Center, and Marshall Health. He oversees the system resources for legal services, human resources, strategy, marketing, information services, and philanthropy. Mr. Smith was previously Vice President and General Counsel for Mountain Health Network, the predecessor of Marshall Health Network, and served as an interim CEO for Mountain Health Network in 2021 before the appointment of a permanent CEO. Mr. Smith is a past president of the American Society for Healthcare Risk Management. He's a distinguished fellow of American Society for Healthcare Risk Management. A graduate of University of Virginia School of Law, Mr. Smith is licensed to practice law in Virginia and West Virginia. He has over 42 years of experience as a practicing attorney, as well as over 39 years in healthcare risk management. Without further ado, I would like to invite our colleague, Mr. Paul Smith, to present on consent and informed consent in healthcare. Paul.
Thank you, Dr. Ranavaya. I'm going to start with a legal disclaimer. Even though I'm an attorney, I am not providing legal advice today. It's more in the nature of operational advice and giving you an understanding of the issues related to consent and informed consent. But as an attorney, I must provide a disclaimer. The learning objectives today, we're going to talk about the legal components of consent and informed consent. We're going to identify those components to be included when documenting informed consent, the federal regulatory requirements governing informed consent, and understanding West Virginia law and case law governing informed consent, including mature minor doctrine and how it impacts physicians' responsibilities. Consent in general. There are 4 types of consent that we often talk about. The consent to avoid a battery. A lot of times you will sign a document called a consent when you come to the hospital for treatment. A lot of what that's designed to do is basically avoid a battery and allow us to take care of the patient, take lab tests, that sort of thing. Included in that is the consent to be responsible for a medical bill. There's also 2 concepts of implied consent. One is in the case of bona fide emergencies. And note that's bona fide emergencies. Going by the consent and saying, I don't need consent because I'm in a hurry is not it. The reason you're going to do bona fide consent avoidance is because of the fact that the patient would suffer if you did not act immediately. There's also a statutory implied consent. When you drive the highways and byways of your jurisdiction, you are impliedly consenting to the application of blood tests for controlled substances, etc., and alcohol. So the statutory implied consent is one of those situations where consent is not needed because by virtue of what you're doing, you've already consented. But the most important is informed consent. And let's take a few minutes on that. The ethical principles of self-determination and autonomy drive the need for informed consent. Now, if anybody who does research, they've already been introduced to the Belmont Report, and I highly recommend it. It's only 10 pages long. It talks about the respect for patients. It talks about the concepts of informed consent from the perspective of research, and it kind of gives you an overview from an ethical perspective of why we do informed consent. However, there are also federal and state legal requirements, and those federal and state legal requirements often fall down into the accreditation standards that healthcare facilities are required to comply with. Informed consent involves a process of communication. It's not a form consent, but it's a process of communication where a patient is enabled to make an informed and voluntary decision about accepting or declining medical care. For the federal legal requirements, the Medicare conditions of participation require that medical records documentation include informed consent. So that's important. Now, what you get informed consent for is sometimes related to law. A lot of times it's related to what medical staff bylaws will say. These are the things that are done in informed consent. Under normal circumstances, you're talking about both high-risk procedures and you're talking about invasive procedures as being those that require informed consent. The elements of the consent, and this is what the federal requirements are: the name of the hospital where the procedure is going on, the name of the specific procedure, the name of the responsible practitioner, and the statement that it was explained to the patient or the patient's legal representative. You know, it's important to show that this was an interactive process. Material risks need to be disclosed, and they could include both high risk as well as those things that are likely to happen. So both frequency and severity can identify something as being a material risk. The responsible practitioner who uses clinical evidence is informed by the practitioner's judgment may determine which risk benefits or alternatives are to be discussed with the patient. Now, I want to footnote this because I'm going to talk to you about the specifics of West Virginia law when we get further in the program. The signature of the patient and the patient's legal representative needs to be included on the consent form, and the date and time the informed consent form is signed by the patient and the patient's legal representative. I know that surveyors pay particular attention to the date and the time that's on the form. So they want to know when the patient actually gave the consent to make sure that the consent was given before the procedure was done. These are some other things that you might include in informed consent: the name of the practitioner who conducted the informed consent discussion, particularly if it's not the attending physician, the date, time, and signature of the pertinent person witnessing the informed consent process, and then the list of the material risks. There's also now, as of April 1, 2024, a statement related to that physicians other than the operating practitioner, including but not limited to residents, medical advanced practice providers, and other applicable students, will be performing important tasks related to the surgery or examinations and basic procedures for educational and training purposes. The idea is to notify the patient that there are other people that are going to be involved in significant aspects of the care. Important surgical tasks, which would be the things you're talking about: opening and closing, dissecting tissue, removing tissue, harvesting grafts, transplanting tissue, administering anesthesia, implanting devices, and placing invasive lines. Examinations or basic procedures conducted for educational and training purposes, as we mentioned before, would include breast, pelvic, prostate, and rectal exams. Okay. There's also, if you have them, a statement that qualified medical practitioners who are not physicians will perform important parts of the surgery or administration of anesthesia, and that those are only within the scope of their practice. For the state of West Virginia, the hospital licensure rule requires that there be a properly executed informed consent and that it be in the chart before the surgery. The case that came up in West Virginia is a 1982 case, but it's still good today. Patient underwent a cystoscopic examination of his urinary tract. After the procedure, he had problems with urination, allegedly became impotent. The physician who was doing this examination did not have an informed consent, but relied instead on the general hospital consent that he signed when he got to the hospital. The court determined that it would apply a patient needs standard in determining whether informed consent was obtained. Now, a patient needs standard is a subjective standard as opposed to a standard where you said there was you were doing what a reasonable physician would do in the same circumstances in terms of the type of information that was provided. So the reasonable physician or national standard is not applicable in West Virginia. The court noted that a physician has a duty to disclose information to his or her patient in order the patient may give consent. And that would include the possibility of the surgery, the risks, alternatives, the risks related to those alternatives, and most importantly, the results likely to occur if the patient remains untreated. So it's important to include as one of the options that this would happen to the patient if they were left untreated. Okay, when you get to court, however, the claim on medical malpractice that relates to the lack of informed consent's got to show that, number one, that the patient wasn't properly performed, and number two, had they been informed, they would not have undergone the procedure, and therefore the event that occurred would not have occurred because they declined. So it is a little bit higher standard. It's not simply a matter of looking at the form. You have to look at both the form, the information that was provided, and look at what the outcome would have been. Because under some circumstances, the patients are still going to undergo the procedure. They don't like the outcome, and that's more of a standard malpractice case as opposed to a lack of informed consent issue. Consenting adults, anyone over the age of 18 is an adult in the state of West Virginia. If a patient has a legal guardian who has the authority to make healthcare decisions, the legal guardian needs to consent. Now, this is important. Some guardianships are based on the person, which means that they have the ability to control healthcare. Others are based on finances. There are some guardianships that are basically designed to take care of a person's money, while at the same time recognizing that the patient still has the capacity and ability to make healthcare decisions. So sometimes you may need to get some help in making sure that whether or not the patient has consent capacity, even though they have a guardian. If they lack decision-making capacity, the medical power of attorney, if they have one, would come into place. And this is a matter of completing a medical power of attorney form. There's also in West Virginia law a process for surrogate, where if a patient is determined to be without decision-making capacity, and notice this is capacity to make decisions, this is not something that we hear a lot of times, which is called the ability to be competent. Competency is a legal determination that goes in a different direction. Here we're talking about a determination that can be made by physicians that basically says, based on my examination of this patient, they don't have the ability to put the things together that are necessary. They can't explain what the procedure is, why it's being done for them, that sort of thing. The surrogacy is set forth in the statute, and it gives a list of people by order of priority who may act on behalf of the patient if there is a determination of incapacity. Limited mental capacity, however, does not automatically disqualify a patient if they have the ability to make independent choices and they're not just merely parroting back to the physician the information. In the case of minors, the normal standard would be parents or guardians. However, when you're dealing with minors that are of a certain age, it's important to recognize they may have the independent ability to consent. In West Virginia, if they're 16 and older and married, they are emancipated. If they're 16 and older and emancipated by a court order, once again, they have the ability to independently make the decisions. The former case I haven't run into. The latter case, it was explained to me that sometimes you will have somebody who will be emancipated by court order because they're starting college and they're under 18. And so they want to be out from under their parents for reasons of financial aid and other things like that. But these are things that don't need to happen. What happens more often is the application of the mature minor doctrine, which is a case-based doctrine in West Virginia that basically allows physicians to identify whether or not a patient, usually the age range is 14 and older, do they have the ability to understand the nature, risk, and consequences of the procedure to be performed and the treatment to be performed or withheld. So there are circumstances in which a physician can determine that the patient in front of them is a mature minor and therefore they can accept the consent directly from that patient. Now, there are circumstances in West Virginia law and the laws of other states where consent is not necessary for certain types of testing and that sort of thing like that, but that's beyond the scope of what I'm doing today. Risk management aspect of this. Informed consent is a process, not just a form, as I said. It is an opportunity to communicate with and build a relationship with the patient. And what's really important is studies have shown, particularly for those physicians who are doing procedures, the ability to have a consent gives the patient and the physician the ability to talk about it. Remember, I told you when we were talking about this case before that this is something that could happen. And it did happen, and it's unfortunate that it happened, but it was one of those things that happens in these cases. So it gives you the ability to walk through those things, particularly when you have a medical misadventure or a bad outcome. The existence of the relationship makes it easier for the patient to accept that bad things can happen, rather than assume that the physician did something wrong. Now, there are two words that I provide as guidance. The first is choice. If you give patients the kind of information they need, that's going to help them make an informed choice. And also surprise. Giving patients information about the sort of foreseeable consequences that may happen, so they're not surprised if something goes wrong. So if you think about choice and surprise, that will help you when you're dealing with the individual patient. Okay, there's the end of the presentation. Now I'm going to get quizzed.
Thank you. Thank you, Paul. Really appreciate the very informative presentation. And I have a few questions, and those questions I'm going to ask on behalf of the audience to make sure that you can further dive into some of the thoughts that occur when we hear this presentation. So the first question I have is, spoke about consent and informed consent in so many ways and in general terms. Are there any specific issues that relate to informed consent in research?
Yes, in research, you need to be familiar with the requirements under HIPAA. Number one, you have a need if you're dealing with individuals and you're going to be sharing their information with a research team and with potentially with a study sponsor and with the institutional review board. You may need to have an individual release that is a HIPAA compliant release so that that information can be shared. In addition, institutional review board, or in some institutions, they have a separate privacy board, has the ability to look through the process and determine whether or not they can give permission to use this information in a recognition of the fact that the research could not go on if it wasn't for in essence, a waiver requirement. So those are a couple of things to do. People who are doing research regularly will understand those, but if you're new to research, or if you're a medical student or resident, these are some things that you need to take account of. Just because you have institutional review board approval or a waiver of approval doesn't mean you've done everything you need to do.
You alluded to patient capacity to form an informed opinion or consent. Do you have any guidance for obtaining informed consent from patients of limited intelligence, advanced age, or mental impairment?
Yes, one of the things ever since I started doing this, that's always been helpful to me is looking at what we call in the law testamentary capacity. That is the ability to make a will. And this is something that's imposed upon an attorney who is helping a client make a will. And that is, they need to understand that they're making a will. They need to understand the nature of their estate, whether or not they're rich or poor or whatever. And they also need to understand what are called the objects of their bounty, which is basically who are their heirs. And a similar process, I think, is helpful when you are in a situation of doing informed consent. Do they understand that they're going to have a medical treatment or procedure or surgery done? Do they understand why it's being done in general terms? You know, here's what you're going to do, it's going to make you better. Are they able to take all of that and come back and say, yes, I understand? And most importantly to me, I think, it's not being parroted back. They're not saying what they think they want the physicians to hear. They're basically saying, I want to do this. So there's at least a matter of choice there. Their ability to understand all of the fine details. As I explained to a physician one time, patients do not have to be rocket scientists to undergo surgery. But at the same time, you need to feel comfortable as a physician when you're doing informed consent. The patient understands that they're undergoing a treatment. They have the ability to say no, and they want to go ahead.
Thank you. That was very helpful. Um, so when is the informed consent not enough to protect you?
Well, this goes back to a case that I was briefed on at a conference a number of years ago. A wealthy patient came in, did not want an extended period of time away from work because time is money for them. They talked the physician into doing 2 procedures at the same time that were normally done one recovery period, then the second procedure. Unfortunately, what happened was what you would expect would happen. Because the procedures were done at the same time, there were complications. The patient did not heal. The patient became depressed, and the patient committed suicide. Because the patient was wealthy, there was an awful lot at stake, so the family sued for malpractice. The physician said, but in my consent form clearly said this was a risk. And the court basically said, yes, we understand that, but just by putting it in writing means nothing. You cannot abrogate your responsibility as a physician to keep somebody from making what in this case was clearly bad judgment. It was clearly against anything should have been done. And the patient, at some point in time, the patient needs to rely on the physician to say, I'm not going to do that.
Well, that's a great insight, underlying that ultimately it is the physician's responsibility to make sure that they prevent their patients from clearly making a judgment that is against the medical advice, and that's fascinating. information. Uh, Now, how are the informed consent issues handled in malpractice cases? Since we are talking about a medical malpractice case that you just alluded to. So how is the informed consent issues handled?
Well, as I previously said, the actual uh, claim related to the lack of informed consent is one that's kind of hard to deal with because of the fact that you've got to essentially prove that, yeah, I wouldn't have done it if I'd known this particular information. But more importantly, how do malpractice cases get started? A patient doesn't get answers to questions. There's a misadventure. And in some cases, you'll see this breakdown in communication. They go to an attorney for answers. The attorney passes the chart on to a colleague who happens to be a physician. When that colleague who happens to be a physician notices that there is not an informed consent in the chart, or that the informed consent is inadequate, then he's going to say, you might want to take this a little further. So one of the things that comes in the beginning of screening is, for a malpractice case, is, does your chart accurately and completely reflect the care and treatment you did and the communications that you had with your patient?
Well, that's wonderful. So not only we are learning about the informed consent, but we are also, in a way, also understanding how the medical malpractice suits can be stopped before they begin by doing a good job of obtaining an informed consent, and more importantly, develop a great relationship with our patients. And as you stated, give them information and no surprises. And no surprises. I think it's one of the best thing I learned today is by making sure that they understand what is to be expected. Okay, I have a couple of uh, questions further before we conclude this program. So the next question I have is, does it have to be a physician obtaining informed consent?
The West Virginia case spoke in terms of the duties and responsibilities of physicians. Uh, it has been interpreted that that would also include a non-physician, such as a nurse practitioner, who was credentialed to perform the procedure, because it does not make sense for a physician to have to come in and consent a patient where the physician's not the one doing the procedure, but in fact, and somebody else who is licensed and credentialed to do the procedure will be doing the procedure.
So the one who is doing the procedure would be in the best place, best position to take the informed consent. But how about fellows, residents, PAs that are going to assist in the surgical procedure? Can they do that on behalf of the attending surgeon or physician?
Well, normally as part of graduate medical education, you're going to see that that's part of the training process for physicians to be able to do the consenting process. Uh, with respect to a physician's assistant, that would only be in nature of a procedure that they might be independently credentialed to perform.
So what I what I hear from you is that it is best for the person, the physician, who is going to perform the procedure, they should do, is preferred that they should be doing the informed consent.
Well, quite often they're in the best position to be able to understand, because another part of informed consent that's not talked about is the patient ready? There may be some procedures that have to be done now, but there's also a number of elective procedures. And the physician is quite often in the best situation because they certainly don't want to operate on somebody who's not ready, who is incapable of doing it. And I've known several situations where the physician wisely said, I don't think this is a good day for you to have this procedure.
Okay.
We'll redo it, because you should always feel comfortable. It is the patient's choice.
Okay. All right. And finally, the question I have is my patient is illiterate. So, how do I get the informed consent form signed?
One practice that has been used is if there is another family member or somebody there, that the family member would then work with the patient. The patient can put an X on the form itself, or somehow indicate electronically that that's theirs, and then have the family member basically explain that this is Uncle Joe's X, so that you at least validate the fact that the person did this. But part of the challenge in this process is making sure that this is just an illiteracy issue, which quite often it is. They can't read. That doesn't mean they can't understand.
So, can a non-relative, perhaps a operating room employee of the hospital or some other person, could serve as validator of the X of Uncle Joe?
Whenever possible, I highly recommend that it not be people who are involved in the care and treatment of that patient, because then there's always a perception, oh, well, they wanted the procedure to go along and that sort of thing like this. But obviously, there are opportunities for people to come in and assist, maybe somebody from the social work area or care management, that sort of thing.
Thank you so very much. This has been a very informative presentation, Mr. Smith. Much appreciated. And to our attendees and participants, I thank you on behalf of the Marshall University School of Medicine for participating in this CME On Demand series today. In accordance with the ACCME accreditation standards, to receive the CME credit, you must complete the evaluation, which now you can access. You are seeing a CME on demand evaluation QR code, and below that is also a link. Either one will take you to a evaluation form. Your feedback is essential for assessing the effectiveness of this activity and for improving future educational program. Physicians, I should mention here, physicians should only claim credit commensurate with the extent of their participation in this activity. This content has been developed in compliance with the ACCME's standard for integrity and independence in accredited continuous education, ensuring it is free from commercial bias. Mr. Paul Smith, nor I, nor any of the planning committee has any relevant financial relationship to disclose that would affect the presentation and the ACCME Category 1 credit for this program. To complete your evaluation and claim your CME credit, please scan the QR code or on your phone or click on the link below to assess the evaluation form. I, on behalf of our CME team and Marshall University School of Medicine in general, appreciate your commitment to lifelong learning and your dedication to improve the patient care and healthcare outcome in our community and your community. Thank you for your participation.